This is Gary Jordan, and this is the second video on the natural law theory. That's what we're going to try to help with the transition from our complex corporate law. What I'm going to discuss today is dispute resolution, or what we would normally use for a court, for a trial, for cases. And I'm going to base this mostly on English common law, because that's what most of us in North America have been exposed to. There are other law systems around the world. Um, those that are listening to us that might be privy to those systems are more than welcome to use features and elements from it if that's more appropriate for you. Because natural law doesn't have any hard and fast rules. It's appropriate to the climate. It's appropriate to the community. Um, so what we're going to do today is go from start to finish from what you would have in a typical situation with an American English common law based natural law court. And I'll start with generalities. Again, none of these are hard and fast rules. A community, virtual or physical, can rearrange things as they need, and this best suits their community and their needs. The generalities will be, for starters, all positions, all roles that will be discussed are temporary. They exist only as long as that particular case is in progress. The minute that case is finished, everybody gets to go home, and it's back to everyday activities for that person. There is no particular authority, power, or dominion with these positions. It is strictly to solve a dispute or the suspicion of a problem and deal with it. The other thing is all positions are from the members of the community. Unlike English law, common law, Roman law, where you could have a magistrate from Timbuktu, Washington, D.C., makes no difference. There are no higher or lower courts. There are just the local courts to solve that particular problem. And it is present time, and there are no precedences. And what that means, it doesn't mean that you can't go online and look for something that might be similar or something that might be of help to you, particularly in the remediation phase when the goal is to restore health and well-being to the victim and the person or persons that have actually caused the harm. So there's nothing to say you can't check things out to see if, or maybe there might be something a little that you might not yourself know about, or that your community might not know about. It's like going online and looking for agricultural techniques or plants that are similar to your climate, or water harvesting techniques that are appropriate for similar topography. Same thing, same idea. That just means that at present, case by case, it has to fit the bill. It can't just be because some judge, king, or something from somewhere out there said to do it. That's the way they did it. You're going to follow. That's not what that's a precedence, and we don't use that in natural law. So, as I said, they are all members of the community. We don't have outsiders unless we invite them in. You know, a particular expert or something that maybe we might want to have for a particular, something that we don't see every day. A community doesn't see it every day. The other thing is that because you're a member of the community, whatever your position and your relationship to a case is, you have a vested interest to see that it is healed, that the community is made whole. You're not some foreigner that gets perhaps better off because it's not working. So that's the thing. You're in the community. You are have no real authority over others, and it's these are all temporary positions. So, with those generalities in mind, let's start from the beginning. Let's say I'm a member of a community, and I see something's not right. Maybe there's some poison in the water or something, and some of the kids are getting sick. So the next thing I would do, first thing I would do is I would call a grand jury. Typical English law, we have this grand jury, and even under our system, it is totally independent of the legislative to regular judicial, uh, um, executive, any of that. It's completely outside that, even under standard common law. It has no, its authority in natural law comes from the people themselves. So, me as a resident of a community sees this problem, and I ask, can we set up a court to find a grand jury to find out if this really is a crime that's being committed, and if so, who or whom is causing it, so we can deal with it and get it stopped so that the kids don't get sick. We'll use that as an example. Say some water looks like it's being poisoned. So you form a grand jury. They're all members of the community. The only I wouldn't even call this a hard or fast rule, but the only thing that you would want to be certain of is that the number of people you choose is an odd number, just so that there's no stalemates. Now, the members of the grand jury are chosen by the parties involved, and everyone who's going to be a part of it has the opportunity to help select the grand jury. Their job is to investigate, to determine if there is a crime. And so they'll call witnesses, they can pull up documents, they can go to the site where the resident saw what appears to be poison. They can have a specialist who knows how to make some kind of test, run water samples in this particular example, and you go there from there. Should a grand jury decide that there is enough evidence in their minds to say, yes, there is a crime, then they would want to, if they can, determine who's causing it or whom is causing it. Where is the poison coming from? And then they might decide there's enough evidence to say person X or group X was doing this and putting this stuff in the water, and they're causing a harm to the children. So then you would take a vote, and the vote would be for indictment or not. That's typically how we would. That's one way we could do this. Um, the next step, if there is an indictment, is the grand jury itself can say, we've made an indictment of this person. Um, we believe there's enough evidence to have a criminal trial, and then the community would pick someone that they feel comfortable with to be the justice. And then again, you would pick jurors. They may or may not be from the grand jury, depending on the size of the community. A minimum of three, because we're talking about different sizes of bands, clans, confederation alliances of these and tribes, and they all have different sizes. Um, so depending on the size of what you have to work with. I mean, you could have the whole community as far as I'm concerned. There's nothing that says you can't have the whole community as a juror. Then you would have the the victim or the victim family if the victim is deceased or is incapable because they're too sick or something to speak for themselves in a manner that would work. It would be a representative for the family and the family group, and they would do their investigation. They would finish anything up that they felt that was tidied up by the grand jury. They would then, once the date is agreed upon, and jurors have been selected once again, both parties will have a chance to. Then the defendant, the accused person or persons, or group of persons, have the opportunity to send a representative to the court. And that person who will present the rebuttal will present evidence showing that the accusation is incorrect or not the cause of the problem. So you would go with that. From this could the whole process could take a couple hours to a few days to a couple weeks, depending on what's being discussed. It really depends. It's a case by case thing. There's no hard and fast rules. Then you have the justice. The justice, like I said, is picked from the community, and he or she is considered a wise elder, someone who had good judgment and good discerning. And then you have the jurors. Again, they're usually picked for the same reason. In a criminal trial based loosely on English common law, the jury's function is to determine guilt or innocence. They have the job of saying, yes, there's enough evidence and solid evidence to convict this person and say, yes, so and so or a group of so and so's actually caused the harm to simply using the poisoned water in a stream. They can say there's enough evidence saying so and so is coming from so and so's house. There's a poison is coming from that, and it's harming the children. The next thing, after both sides have had a chance to to argue their cases, argue their positions, and the jury has decided guilt or innocent. If it is decided by the jury that the accused, the defendant, is guilty, the justice, his job or her job, is to work on the remedy. It might be in the case of this fictional water poisoning of a stream. It might be something that the defendant doesn't even know is happening. He might not even be here. The family might not be aware that this is happening. And so the remediation, it's not about punishment. It's not about doing like we're so good at doing in America and in the UK and other English and Roman-based law systems. Eye for an eye, tooth for a tooth. No, it's not about that at all. The justice's job is to look at remediation, both for the victim and for the accused, so that both are healed and that the community is brought back together again. And so that when this is said and done, everybody is actually healthier and better off for having gone through this experience. At least that's the way I see it. And that's how a case is done. And when it's finished, and the community takes responsibility for helping the remediation. This is where a lot of groups like the Somali and the Native Americans, they had their clan. You were not expected, either as a victim of a crime or as someone who'd done the crime, to shoulder the whole burden of the work yourself. You had your clan, your family, your band, and the rest of the tribe to help you. And so the community bands together to take what the justice has suggested as the path to remediation. It's agreed upon that yes, this would probably work, and I would personally, if I was in that position, I would say, as the justice, in such a case where you actually had a defendant and a prosecutor, I would say, will this actually help the person? Does this person have a sickness? Does this person, depending on what we're talking about, if he's hurting somebody, does he have a sickness? Does he have something that he's in pain? And you just have that, the victim happened to be a trigger or something, in the case of the water thing, is he doing something that should not be being done in that place? Maybe help them find another location that won't poison the water or hurt the community. so they can accomplish what they need to accomplish. Or maybe they're making drugs or something to deal with a psychological issues that they're not being addressed. And so you find whatever that is that will bring healing. A justice also has the option, in my view, of asking the jury to help him or her with the remediation process. If they feel that they're not confident enough for this particular thing, or they want to have a second or third opinion, like a doctor might for for a diagnosis of an illness. You might want the second, third, fourth, fifth, sixth, ninth, 12th opinion of the jury to give an idea of just how well this is going to work for the community. Since every member of the jury, the prosecution, the defense, as well as the justice, him or herself, are members of the community. They have a vested interest to see that the healing that might be needed is done. So that's how a case is done. And then once it's finished, once um, uh, the determination has been done, then it's just a matter of going through the follow through as far as the remediation process, um, and whatever that is for the particular case involved. Again, it's a case by case. No hard and fast rules or no timelines or none of that. That's not like English common law or even, especially not like our corporate law, where everything is ceremonial. It's almost like a priest going, a bunch of priests running around with big ceremony. It's not ceremonial at all. Courts can be held virtually. Grand juries in criminal trials can be held in person, virtually over Skype, telephone conferencing. You can hold it in a building. You can hold it under the tree. In fact, in Somalia, that's what they do. Their trials are held under a tree. There's no right or wrong about a lot of this. But this is to give you an idea for your community, for your group of people, your band, your clan, your confederation of these and tribes, to transition from our very complicated, very rural, every little T's got to be crossed the right way, every little I's got to be dotted just the right way system. And hopefully, I'm hoping this will be of help to you. I'm hoping that you'll get a sense of how um, natural law can work for you and your community. And so, with that, I hope you all have a wonderful day and see you next time.